IP, but this actually covers quite a range of types of creative ideas. Paul, can you take a crack at walking us through the different forms of protection for the different types of IP?
Well, sure. Recognizing that it's really just a very light touch on all of these, if we look at the suite of laws that we have in Canada for capturing intellectual property, we have for inventions, and that's a term that can cover pieces of equipment, it can cover methods, it can cover chemical molecules, it can cover those aspects that are defined in the Patent Act as being patentable. What it does not cover are ideas or abstract theorems. So there's patent protection for that. For branding items such as logos, names that are related to products or services, we have trademarks, and both trademarks and patents are the subject of an application, a review by our government agents under the Canadian Intellectual Property Office, and then following the satisfaction of the criteria in that review, the asset is issued or granted. We have copyrights under our Copyright Act, which can cover music, drama, literary works, and those are created and recognize that law upon their creation. So there's no formalization step that's necessary. There's a very important additional right that comes with copyright, and that's something that we call moral rights here in Canada. And then the last would be trade secret, which is a subset of confidential information. That's recognized at common law. And certainly, unlike the states where they have a Uniform Trade Secret Act, here we have a three-part test that really boils down to the notion that the subject matter of the trade secret drives or retains commercial value by virtue of it being secret, and it is the subject of reasonable efforts to protect its secrecy.
You have a wonderful example about the Ford Mustang and the different types of intellectual property within that vehicle and the different methodologies that you've just described that were used to protect those different aspects of the vehicle. Could you use that as a bit of an illustrative method of further explaining what you've been describing?
Well, sure. So I'll start with perhaps what really jumps out for me when I think about a Mustang. It's the horse logo that's found right in the front grille. So that would be the subject of a trademark, that's a logo or brand. If we think about the process of actually designing that particular vehicle, we can imagine that there are a series of drawings that were essential for the design, and those drawings would have copyright in them. We know that there's an airbag system to meet our safety regulations in Canada, and we also know that the airbags in the Mustang have been the subject of a patent. So that's a nice way of sort of looking at one product that's quite familiar to us and being able to see that there are numerous opportunities for capturing and creating intellectual property assets and using those to really drive a revenue stream.
One of the areas that's complex and costly around patent protection is the idea of jurisdictions and what's actually covered and the rationale behind all of that structure. Can you walk us through a little bit of that?
Well, sure. So patents are really a creation by our government for the purpose, ostensibly, of disseminating knowledge. So there's a quid pro quo that's at play with the government, and that is that in exchange for disclosing your innovation, your idea, and publishing that, making it available to the public in a way that it advances the state of the knowledge in our society, the government will give you an exclusive monopoly for that technology, that invention. in the form of a patent. So you have to disclose your knowledge in a way that it can advance the state of the knowledge in society in exchange for that monopoly. The rights that are associated with a patent are exclusive, and they encompass the right to use the invention, the right to make or have the invention made, and the right to sell the invention. So quite a bundle of sticks there. With the patent, the hammer that you have as a patent owner is really to, we'll take a product as an example, is really to look at an infringer, and your legal remedies are that you can shut the infringer down from pursuing or continuing the infringing activity, have the infringer deliver up all infringing products, or have them disgorge all of the profits that they have received in selling that infringing product. So you can see that that's a tremendous enforcement hammer for you in the marketplace. There is quite a bit of strategy, however, in, for example, pursuing a patent. And some call it the stick and carrot strategy, where the stick, of course, is the patent you have the ability to enforce, and the carrot is that perhaps there are aspects of the patent, of the subject matter in the patent that haven't been disclosed, and that help someone taking that technology or that invention and optimizing it. And so having some technical knowledge, some know-how, and being able to license that as well is somewhat of a carrot and stick strategy.
Can you describe what a patent database search actually tells you and what it doesn't tell you, most importantly?
Sure. So when I think about that question, there are four important facets that come to mind. So the first is really looking at the technical requirements for patentability. So when we talk about the database, what we're really talking about is something that's coined as prior art. What technical information is out in the public domain, whether it's literature or other patents, that are relevant to the venture's invention. This goes to the legal test for patentability, and I'm not going to go into the elements there, frankly, because I find that too often in talking about the test for patentability, too many engineers in particular, but inventors self-select and offer up defenses, if you will, or rationalizations for not pursuing patent protection with beliefs such as it's just good engineering practice or it's just my job and what I do. So in terms of the test for patentability, in that, that first sort of threshold question is, do you have something that's patentable? I would say suspend your disbelief. And if the solution that you have has commercial value, there is certainly something in the intellectual property space that we can use to further your business objectives and presumably a revenue generating stream. So that's the first part is the technical requirements for patentability by looking at what we call the prior art landscape. The second really is equally important, and that's market intelligence. Lets you know who's active in the space. It should give you some appreciation for what their technology development trajectories or pathways are. It should also perhaps indicate to you, depending on how far you do your searching, how invested they are in their technology or their inventions, how much they're spending, whether they have a purely offensive or a defensive strategy in terms of their protection. So lots of good information there. It will tell you who else is in the space, whether it's a crowded space and there's a lot going on. And this is all important in understanding where there is an opportunity for you to stake out your claim for your invention, staying away from places where there's overlap, or perhaps going into places where there's overlap, again, with the right strategy and thinking. I guess I'd like to close with the thought that looking at the technology landscape, if you will, the patent database, it's as important to consider that exercise as part of the innovation process. What it does is it shows you what other solutions have been tried to your problem and should be an opportunity for the inventors to stress their own appreciation for the solution that they've developed and perhaps evolve that understanding or evolve their solution.